kick us off.
All right, Ann.
Thank you, Christopher. Welcome, everybody, to the fifth and final installment in the series Abuse in Later Life, a webinar series for civil attorneys and legal advocates, presented by the National Clearinghouse on Abuse in Later Life and the American Bar Association. We are super happy to have you here, and a special shout out to everybody who has attended all 5 sessions. This series is funded by a grant from the Office on Violence Against Women, and we are required to let you know that the opinions, findings, conclusions, and recommendations that you're going to hear today are those of the presenters, and they don't necessarily reflect the views of the Office on Violence Against Women. I'm from the National Clearinghouse on Abuse in Later Life, and we are co-sponsors of this webinar. We are the comprehensive technical assistance provider for the Office on Violence Against Women Abuse in Later Life Grant Program. Since 1999, NCALL has been the only national organization that provides technical assistance, training, and consultation at the intersection of elder abuse, domestic violence, and sexual assault. We are a national project, and we are a small but mighty team of 5. And I'll turn it over to Ruth to talk about the commission.
Thanks. Hi, everyone. Welcome. My name is Ruth Perrin. I work at the ABA Commission on Domestic and Sexual Violence. We are a technical assistance and training provider to organizations receiving funding from the Office on Violence Against Women. We primarily provide training and technical assistance to civil legal services attorneys working on cases involving domestic violence, sexual assault, and stalking. We can provide you with individualized technical assistance, organizational support, and trainings. We have a number of resources available on our website, including publications and statutory charts. And we host 6 listservs for domestic violence professionals throughout the country, which you can apply to join on our website. We regularly advertise our upcoming trainings and webinars on our listservs and on our website. And we can provide technical assistance, which is one-on-one support to attorneys or organizations to support you on a variety of topics. I will put the links to request assistance in the chat a couple of times today.
Thank you, Ruth. Just to respond to one of the questions in the chat, all 5 of these webinars, the recordings will be posted on the NCALL website. That's NCALL.us. And they should be up in the next month or so, but we will post them all in a group so you can review them if you missed one, or if you're just really a super fan and you want to watch them again. Today we are in module 5, and we're going to be talking about trial skills and bringing the case. So far we've talked about an overview of abuse in later life and how do we build that relationship with that older client. What are some things that are different than building a relationship with a client who might be younger? We talked about working with the client to identify and set their goals and some non-litigation responses that might be appropriate. And then last week, we talked about some legal resolutions and remedies. And then again, today, we're going to get into some trial skills. I'm going to turn it back over to Ruth.
So the overall webinar series learning objectives are that participants will be better able to, 1, identify and describe key dynamics of abuse in later life, 2, effectively recognize and respond to cases of abuse in later life, 3, access client-centered community-based resources, and 4, provide effective client-centered information and advocacy to abuse in later life clients. So today we're going to focus on bringing the case and talk about some of the important information to consider when preparing to bring a case involving abuse in later life. So the training objectives for today's module are that participants will be able to, 1, identify and preserve evidence and testimony, 2, develop an elder abuse case theory, and 3, prepare witnesses for direct and cross-examination.
I can start out by introducing myself. My name is Ann Lotch. I am the Justice System Coordinator with NCALL. My job with NCALL is to work with OVW abuse in later life grantees and really anybody who is related to the justice system or trying to find better ways for the justice system to respond effectively to older victims who have been abused, and with a focus on offender accountability and victim safety. Before I was at NCALL, I was a legal services provider in Milwaukee, Wisconsin, where I live. And I'm super happy to be here today. And I'll let Ruth introduce herself.
I'm Ruth Perrin. I'm a senior attorney with the Commission on Domestic and Sexual Violence at the ABA. And I've been there for almost 3 years. I provide training and technical assistance to civil legal services attorneys. I primarily work on our 2 LGBTQ specific projects where we provide training and technical assistance to really any client-facing staff at legal services organizations to support them in making their services more inclusive for LGBTQ survivors. And we also train judges and prosecutors through that project. And I also work on our other projects where we support legal services attorneys in civil litigation on behalf of survivors more broadly. And before joining the ABA, I litigated for a multidisciplinary organization in Washington, D.C., where I represented survivors of intimate partner violence, sexual assault, and stalking in civil protection order cases and in on-campus adjudications, so typically under Title IX. I also represent survivors of all types of crime in criminal cases, helping to enforce statutory victims' rights. So I'm excited to talk today about some litigation skills. First, Anne, were you gonna?
Yeah, so if you guys would not mind keeping yourselves muted, that will help everybody else hear better. We've had really great participation in this series throughout all of the sessions. You guys have really brought your full selves to this, and we appreciate it so much because I think we all learn from one another too. So please keep it up, and we'd be happy to have you share your experiences or your questions throughout. When I'm talking, Ruth is going to be keeping an eye on the chat, and I will do the same when she is talking. So don't be shy about using the chat. I will turn it back to Ruth.
All right, so we're going to start first with talking about interviews and specifically focusing on client interviews. So really, this is one of the first steps you have into to bringing your case. Conducting an effective client interview or witness interview is really foundational to planning for litigation, for actually litigating in court. Some of the goals of client interviews are fact gathering, but also it's really important to build trust and rapport with your client and help you understand their mindset and goals so that you can really effectively litigate on their behalf. So to prepare for interviews, before interviewing a potential survivor of abuse, attorneys should always prepare to make sure their clients feel comfortable and safer. We're not always able to conduct interviews in person, but in general, with in-person interviews, it's really important to think about the space that you're in, and consider what barriers a person might have to accessing the space. Can someone enter and exit easily, even if they have mobility aids like a wheelchair or a walker? Is where you're meeting them conveniently located? Is it private and quiet, so that the person you're interviewing feels comfortable having a conversation? Can you both hear each other? And it's definitely the best practice to meet with a client alone at first, so that as an attorney, you can discuss confidentiality and privilege and make sure they know any potential issues that might come with having a third party in a room between an attorney and a client. So you first need to have that conversation with the client about the potential ramifications on privilege of having a third party present. Of course, there are some exceptions to whether or not a third party actually breaks privilege, because sometimes it can be necessary for effectively representing the survivor. But this is something that you should be really well versed in speaking about in non-legalese, so that you can talk to clients about privilege, about confidentiality, so that they can really make an informed decision about who's going to be in the room with them. With initial client interviews, particularly with domestic violence and abuse in later life, can sometimes take a really long time. So it's important to kind of remember that from the very beginning and keep your client's well-being in mind, and make sure that You get enough information from them in the first interview, but don't feel pressure and don't put pressure on the client to get everything done in one interview. Sometimes if at the beginning it's feeling like you might need a couple of interviews to get all of the information you need, just start at the beginning then, scheduling another interview so that you don't feel rushed and the client doesn't feel rushed or exhausted to trying to get everything done in that first interview. Another potential strategy that attorneys can use when interviewing older clients is to record the interviews, especially if there's a concern about potential loss of capacity. Of course, this is something you'd need permission for. You need to talk through with the client, explaining the pros and cons, any effect it might have on confidentiality and privilege, especially if there is a third person in the room. It's important to be respectful of your client, and this can mean different things for different people. For older generations, sometimes that does mean being more formal until you're told otherwise. So you want to make sure to ask the client how they want to be addressed or default to saying Mr. last name, Ms. last name, and treat the client, as if they were a family friend or a friend of your grandparents who, you want to be warm with, but formal. That approach, of course, might not work for everyone. Some people prefer and are more comfortable when you speak more informally, but just follow the cues of the person that you're working with to understand how they want to be addressed and spoken to. So sometimes when you're working with someone accessing services, an older victim and perpetrator or caregiver will all come to the office together, depending on the reason that you're working with them. And so in that situation, it's still important to be really respectful of the perpetrator or caregiver, even if you have concerns that that person might be engaging in abuse. You want to minimize the possibility of additional abuse to the parties when the parties leave your office. It's similar, to domestic violence, where you really need to be cognizant of what options make the client the most safe, even if that might mean not immediately intervening or immediately addressing the suspected abuse. When you're working through interview questions, you want to make sure you're explaining everything you're asking. What questions are you asking the client? Why are you asking them? Giving that context can really help people feel much more comfortable answering questions, especially ones that might be of a sensitive nature. If you're pausing and taking notes, whether it's on a laptop or by hand, it's important to just mention, hey, I'm taking notes throughout this interview. I want to make sure I remember some of the really important things that you're telling me. If I don't respond right away, and especially if you're on the phone and the person cannot see that you're taking notes, it's important to just say, hey, if I'm not talking, I'm just taking notes. It's just important for me to be able to prepare your case effectively. I want to make sure I highlight the most important things you've gone through, and or whatever it is that you're taking notes on, just explain that for the client. Once you finish your first meeting, you should explain the next steps, as well as the processes for any legal remedy that the client is seeking, and really provide that foundational information so that your client feels more prepared to interact with whatever systems they might have to encounter going forward. During initial interviews, it can be really helpful just from that first conversation, when you understand what the client needs and what you might be helping them with, to start taking notes on what evidence you'll need and where you might find it. So considering if there are any medical records, financial records, are there recordings that you might need? Are there 911 calls? Are there photos? When I used to litigate, one thing I would always do would be take notes on my computer of all of the things that the client was telling me, but I'd also have a Post-it next to me where I'd write the evidence that I knew I needed to collect, so that right when I was done with the call or the meeting, I could email the client with a list of the things that they needed to send to me. And it can be overwhelming sometimes to discuss in the same conversation first all of the details of what a client has been through, and then also say, all right, here's the next steps. Can you send me A, B, C, D? That can be really overwhelming. So making sure you kind of separate right from the outset what the potential evidence is, and prepare, a future conversation about it can be really helpful. You also might want to start identifying potential witnesses with the client and getting their contact information and consent from the client to reach out to the witnesses. And having that information can really help the attorney assess the strength of the case and better advise the client about their case from the outset. And making sure that you know, the relationship between especially in cases involving abuse, the relationship between the witness and your client, as well as the witness and the perpetrator, can be really important. So you know really what you might be encountering when talking to the witnesses. So specifically for preparing to meet with older survivors, there's some additional steps to take that can help to accommodate some potential issues that older populations might have. So there might be, like with any age group, there might be literacy issues, or they may primarily speak a language other than English. And that can, you know, play out differently in older populations. And people might have different abilities to speak English versus write English or read English. And older survivors may have experienced physical illnesses and have lost some of the ability to read or to write, even, you know, where they are still fully competent to receive legal services and, you know, act on their behalf legally. And so along the same line, you do want to think about the space itself. When you're meeting in the office, is it ADA accessible? And if not, is there an alternative location that you can meet them that is accessible for them? Is it quiet, safe, and comfortable? If there are written documents that you'll need to go over with them, like a legal representation agreement, is it translated into any other languages that it might need to be in? Are you able to, I mean, first of all, is your legal representation agreement written in a way that is accessible for people generally to understand, non-lawyers specifically to understand? And are you prepared to walk through that representation agreement with the client? And then if anything needs to be signed, it's important to have pens that are easy grip and easy flow so that it's easier for people with physical barriers to sign documents. You should also consider the potential that someone might have visual difficulties. So if you have documents and or records that you have to review with the client, try to have good lighting and a magnifier in the office. And if possible, you can produce written materials in larger print. It's also possible that older clients experience hearing loss, and you may need to speak loudly to clients. So when doing so, make sure you're thinking about balancing that with privacy needs and making sure that you're not speaking so loud that people can hear that are outside. You might consider having a, oh my gosh, what are those called? Noisemaker, a white noisemaker. There we go. Outside the office to make sure that nobody can hear. And, you know, making sure that your services are as accessible as possible for people with, you know, physical or mental health needs can not just benefit, you know, specific clients with those needs, but generally, you know, have an effect beyond that and make your services better for all clients by making them more accessible. A really critical issue when working with survivors of elder abuse are allegations of dementia. So it can be really important for an attorney to determine whether the client is competent and through an independent capacity assessment, if possible and if necessary. Dementia is often used as an alibi for the abuser, and they often use an allegation of dementia to justify things like controlling conduct or other forms of abuse. And so, you know, making sure you have all the records about whether or not there have been previous competency proceedings, if there are specific diagnoses like dementia, if, you know, you need to get medical records or the legal proceedings, documents from legal proceedings, or, and so if those things are an issue, it's important to get an independent capacity assessment from someone in your community so that you have that information about the client independently. Attorneys should also be aware of sundowning and its effect on older individuals. Sundowning is a medical phenomenon that affects individuals with Alzheimer's and dementia, and it involves a change in cognitive ability and attitude in the evening or night when the sun goes down. Attorneys working with older survivors should make sure to ask clients when they like to, or when they'd like to meet, and when they feel best, and when they feel like they could, have difficult conversations. And if individuals do experience sundowning, it can be better to schedule meetings earlier in the day. And if the client has a caregiver involved, they might have good insight about the best time to meet with them. So when you're interviewing your client, there's some areas of inquiry that you should focus on. It, is important to conduct the typical domestic and sexual violence screening questions that you might ask of any client. But remember that not all older victims will identify readily as victims or as having experienced domestic violence or sexual violence. Survivors of abuse in later life may be especially protective of the perpetrator, who might be a family member or a caregiver who they are dependent on. So you can start by asking general open-ended questions and then narrowing down the facts from there. So, what happened? How did that start? How did that end? How are you feeling during that? It sounds like you're saying you were afraid. Is that right? And you can also ask about, well, has this person threatened you, or have they, threatened your friends or your pets or things like that? You can ask broader questions to assess the history of the relationship with the perpetrator. So if it seems like the client is really open to talking about the potential of having experienced domestic violence, then you can bring out, the power and control wheel to talk through general concepts of domestic violence to help someone familiarize themselves with what power and control can look like and the different aspects of abuse. Because I think especially with older generations, there are just certain aspects of abuse that people don't, beyond physical abuse specifically, that people don't necessarily see right away. And so talking through those concepts, if the client is receptive to that, can be helpful. But at the same time, always respect the client's boundaries and willingness to discuss those topics. It's important to ask about clients' long-term goals and make sure you understand what it is that the victim is seeking through whatever legal action they're trying to take. As we often see with intimate partner violence in general, we see that survivors often want to continue having contact with a perpetrator when they're experiencing abuse in later life, often because it might be a family member, there's reliance for financial support or care. You should ask the client if they have any concerns, whether it's about their legal case or about going to court or about, tomorrow, what's going to happen tomorrow. And that way you can kind of figure out what it is that's important to the client and what's on their mind. Sometimes clients might say something that you don't realize is a big concern of theirs because it's not exactly on your radar. So I once had a client where we talked through the evidence that she might have, and I told her about taking screenshots on her phone, and she didn't want to tell me that she didn't know how to take a screenshot. And so, and of course, I should have asked, or I should have just, since we were meeting in person, I should have just asked if I could look at her phone and, use something to take a picture. But after I asked, okay, these are the next steps. This is what this is going to look like. Do you have any concerns? And she said, well, I'll have to figure out how to take screenshots. And I said, oh, no, you don't need to do that. Like, I will, if you're more comfortable doing it yourself, I'll walk you through it. Or if you would want, I can take your phone and do it right now. And just kind of figuring out what people's concerns are to help, because there's often a lot of things like that where you can actually help very easily with something that someone might be concerned about, and you don't know if you don't ask. And then I already mentioned evidence a little bit, but thinking about evidence right up front can be really helpful. Noting potential evidence either that exists or that might exist as you talk in your first meeting, and then making sure you kind of follow up on the evidence as like a next step rather than trying to do all of that at once can be helpful. And it's always helpful to ask what the abuser will say happened. And you should always explain, I'm not here to judge you. I'm on your team. I want to make sure that when I walk into court, I know exactly what it is that the perpetrator is going to say so that I can help make sure that we respond to that in a way the court will understand, and help the court really understand, the full picture so that the perpetrator won't be able to, say incorrect things or not give context. So I think sometimes when you ask, what will the perpetrator say happened, it can sound almost like an accusation, or what will this person say about you? But just making sure you explain why you're asking and explain that it's coming from a place of wanting to be prepared to really effectively litigate their case can be really helpful. So when you are interviewing witnesses, obviously you're taking a slightly different approach. You're still doing fact gathering and similar preparation, especially if you're meeting in person. Is the location safe, comfortable, accessible? Especially in elder abuse cases, sometimes the witnesses will also be older. So you're going to want to consider the same things with regards to accessibility, both in terms of any documents you might need someone to look at, or the physical location. You want to know what the current relationship is with both the client and the abuser. And of course, when you're talking to witnesses, it's always important to say up front, that you are the attorney for the client, that you're not the attorney for the witness, the person you're speaking to. You don't have confidentiality or privilege with that person specifically. And just because sometimes people talking to attorneys kind of sometimes assume, if they haven't worked with an attorney before, that if they're speaking to an attorney, they have some sort of privilege, even if they're not the client. Attorneys should also ask witnesses what their interests are in moving forward with testifying, if that's something they would like to do, if they have any concerns. That can help you understand kind of where they're coming from and what their motivation might be for speaking to you or being involved in the case, just to make sure that there's not anything going on that you're not seeing. And then, if there is evidence that a witness has, you should make sure to gather that evidence and then introduce it during the case. Just drop a pen. All right. So some possible questions. Oh, no, sorry. This is you, Anne, isn't it?
That's all right. So just as Ruth was going to say, some questions that you may want to ask an older victim that can just help you get some more information or get a clearer picture of what other evidence might be out there is if they have told anybody about what's going on. They may think, maybe they have contacted APS, maybe they've told a healthcare provider or a caregiver or neighbor, but maybe they haven't, and maybe they've disclosed to somebody that they wouldn't normally think of as a potential witness, like maybe a faith community leader or somebody like that. Also, there may be relevant records that are out there that that the person isn't thinking about. So obviously, if they've been in contact with APS before, that would be a good place to start. If there is financial exploitation, you're going to obviously want to pick up bank and credit card and financial records. I would say even if they're not aware that financial exploitation is going on, if there's other stuff going on, we know, as you've heard us say in every session of this webinar, that forms of abuse often co-occur. So I would be taking a close look at the finances anyway, just to determine if anything is going on. There may be court records from previous cases that would be relevant or that might have something to do with the issue at hand. So just be prepared to have them think outside the box and to really, kind of rack their brains for anybody who might have an awareness of what's going on, or who might have witnessed something, or who might have been present when, something went down, even if it wasn't overt. Sometimes people pick up on things. So those are a few places to start. And then, okay, you're not advancing now. There we go. You want to find out not only what medications the victim is taking, but also the abuser. And then you want to know what effect those medications might have on each individual. If you do a lot of these cases, you're going to start to develop an understanding of what various medications do and their side effects. And when they tell you what they're taking, it's going to give you some insight into their mental state and their potential mood or cognitive functioning. Because we know some medications might make you drowsy or might make you feel indifferent about what's going on in the world. We know that medications are often used to facilitate abuse as well. So really important info to get for both parties. Additionally, you want to ask the older victim kind of how their household or home is run. Like, what are the rules? Everybody has in their household sort of spoken or unspoken rules about who does what, or just practices about who's doing what. Are there certain processes or protocols that they follow typically in the home? If there are caregivers or attendants or nurses, like what is their role? How does that work? When are they coming and going? Who's in the home? Have those people, like the identity of those people, changed over time? Is it a situation where there are many different caregivers coming and going, or is it one person? That sort of thing. So when you are interviewing potential witnesses, attorneys should be asking similar questions about their capacity, their potential medical issues, and any concerns that they might have. And then just some basic accessibility considerations if you are going to court with an older survivor. If the survivor has mobility limitations, certainly not every older person does, but some do. Are they able to access the courthouse, get to the courtroom, get up on the witness stand if they're going to be required to get up on the witness stand? Does the witness have any unseen issues that need to be addressed? Like maybe they need to take, frequent breaks to stand up and move around, or maybe, as Ruth was alluding to before, maybe there are times a day where they're not as alert and it's going to be a problem for them to stay alert for a long period of time. Are they going to need to take breaks? Will they need to eat or take medications during the course of the proceedings? Are they going to need some oxygen? That sort of thing. If it's at all possible, and I know that it is not possible in every jurisdiction or every courtroom, but if it's possible and your client is able to, it's really helpful, and it can reduce their stress so much if you're able to visit the courtroom with them before the actual hearing. So they know what to picture, they know where they're going to be sitting, they know what the environment's going to look like. I know if it were me, I would feel a lot better knowing what I'm going into than, because there's enough that is scary about a trip to court, especially when you're facing somebody who has been harming you. So the more we can make them comfortable and sort of address some of what their concerns or fears or hesitations might be ahead of time, it's really going to put them at ease, and it's going to make things go more smoothly. All right, I'll turn it back to Ruth.
So talking a little more about evidence, you should think about building your case in a couple of different ways. What do you have to prove in terms of the elements of the statute, and also what is your case theory? And then think about what evidence, fits within those things. So when you think about testimony, you should review any interviews that are available with victims or witnesses, anything audio or videotape. And I'll discuss recorded testimony itself in a minute. But in general, it's important to remember that testimony is evidence, and often it's really important evidence. Sometimes, a lot of times when I worked mostly with sexual assault survivors, and they would often tell me that they had no evidence. And it's important to remember both yourself when you're building your case and to remind your client that testimony is actually a very important piece of evidence. You can use subpoenas or, other discovery methods to obtain records from the police, from medical providers, adult protective services, if there are previous court proceedings, bank records, credit card statements. And, it's going to depend on the facts of the case, but those are all things you might look for. Pictures can be really valuable evidence for cases involving physical violence. You can take your own photographs. You don't necessarily need to rely on police images. And you can, especially if, the incident or injury was recent enough. One way to photograph injuries is to use 3 different pictures. So an injury up close, a picture of a little more zoomed out that shows the body part that's being photographed with the injury, and then take a photo of the entire person where you can see the injury. So, if someone had a bruise on their arm, you would photograph the bruise up close, then the entire arm with the bruise, and then the person, with their arm and their face in the picture and make sure the bruised arm is visible in the photo. I'm sure, as you know, the person who takes a photo doesn't have to authenticate it. It can be authenticated by anyone who has knowledge of what the injury looked like. And so the survivor themselves or anyone who saw the bruise around the same time can testify that the picture of a bruise on an arm is accurate. Sometimes you'll want to have pictures of locations where incidents occurred because it can help the court understand, the actions that took place if they understand the space that they were in. So in terms of 911 calls, a lot of times we'll know that 911 recordings exist. Either the client or someone else called 911, and you can usually obtain copies of the call from usually through a subpoena or other process used by your jurisdiction, and it really varies a lot jurisdiction to jurisdiction about who you request 911 records from and how you go about doing it. It's important to gather evidence like this, so getting the 911 recording, even if you may not use it in court, you want to use it to see if it has good information, if it identifies if the caller identifies the perpetrator and the relationship between the perpetrator and the survivor, if there are any witnesses that are identified, and if there's any part of the incident that can be heard in the background, such as, somebody yelling or banging on a door or anything like that. So a couple more things about 911 calls. It can be helpful to know how the police responded. So you'll often want to get a copy of the police report as well. And understand from conversations with the client, from the 911 call and from the police report, what happened after police were involved. Was anyone arrested? And listen for statements from the parties, witnesses, or police officers that you might want to use in your case when you're putting it on in court. If the police took any photographs, you should request those. If there's an ongoing police investigation, sometimes police are going to be unwilling to provide those photographs. But it's still important to try to request it. And when deciding whether or not to use a recording in court, you should ask, does this corroborate the survivor's testimony? Does it advance the client's case at all? And, if it doesn't do anything for your client, especially if it might undermine any of your client's statements, you should consider not using it. So looking at medical records, that's another really important piece of evidence to look to. And it might be both the client's and the perpetrator's medical records, depending on the circumstances. Medical records can be a really sensitive or difficult strategy because some clients may not want anyone, including you, seeing their medical records. And sometimes there can be a significant burden to requesting the perpetrator's medical records when the perpetrator, is unwilling to provide them. And so it's a really good idea to talk to your client about the positives and negatives of using records. And at the very least, to talk through with your client, you as their attorney looking at the records to understand some of, what they're experiencing, what medications they might be taking, what diagnoses they have, so that what the client is experiencing. Looks like somebody's raising their hand. Jane Handley, do you want to ask your question? I don't know if you can unmute or in the chat ask.
Oops, I must have bumped that by accident. I'm sorry.
No problem. Okay. So with medical records, you can see if a party has any known or diagnosed medical conditions. Sometimes if a perpetrator is alleging that the client has dementia, you'll need to see if the medical records corroborate that. If there are medications that might affect someone's ability to perceive and recall events. If there are any toxicology screenings, it would be helpful to have those, especially where there might be concerns about over medication or abuse related to medication. And then also medical records might also have injuries and photos of injuries. and will offer, the overall medical history of the client. So again, when you're looking at medical records, you're going to want to determine, after your own review, what does the evidence corroborate or make it clear to the court is undisputed, whether it's positive or negative, and talk through with your client if you do decide that the medical records are going to help your case, and talk through what it would be that you'd be presenting to the court, how it would be presented and why, so that they can make an informed decision about that strategy. An example where you might want to use medical records is if you have a sexual abuse case and the survivor experiences dementia. There might be a note in the record saying that the doctor discussed the dementia with their caregiver or perpetrator, and that the perpetrator knew that the person had dementia, and that would help prove an element where the perpetrator knew that the survivor wasn't capable of consenting, depending on the details of the situation. 911 call part 2. I went through this already. All right, so injuries. Documenting injuries is really important, or finding documentation of them. So whether that's taking pictures, gathering pictures that were taken by the client or witnesses or police, and or creating documentation by taking photos yourself can be important. If your client has mentioned that they had older injuries from previous incidents, you might want to see if there's documentation of those, whether that's in medical records or in pictures that the client took, or that might be in the the phone of a friend of the survivor or something. Asking the client for caregiver documentation. The caregiver may or may not be the perpetrator, depending on the circumstances. And so if there is a caregiver who may have taken pictures of the injuries someone had, it can be helpful to use that as additional evidence of abuse. And caregivers may, be documenting what they're seeing with someone that they're caring for, and learning to, and making sure that you're speaking to the caregiver and talking about, any documentation they have, and if they could be witnesses or potentially have photographs, could be helpful as well. So when collecting potential witnesses to provide testimony on behalf of your client, of course, talk through with the client the types of information that might be helpful. Sometimes people don't readily mention different things people know because they don't know what legally might be helpful in their case. So talking through the types of information that can be helpful. So rather than saying, did anyone see this happen, or do you have friends with knowledge of this incident, or something like that, you can say that anyone who you told right after the incident, or did you call anyone shortly after, did anyone or have you disclosed this to anyone? Things like that, just kind of asking potential witnesses that you don't know necessarily exist, but like categories of people that may have information can be helpful. If you're asking about incidents, you can say, did you see anyone later that day? And, would it be okay if I talked to them so they could tell me, what your mood was, or something like that? Because people don't necessarily know what information is helpful legally. The client might have disclosed abuse or symptoms of abuse to friends or family, to caregivers. And there also might be people who have witnessed abuse or signs of abuse, but not necessarily mentioned it to the survivor, depending on the specific circumstances. So if there are people who are frequently around the survivor, it can be helpful to ask to talk to them as well. Encouraging your client to think really broadly can be helpful. And that can help, really corroborate the survivor's story and, the events that have happened. So I'm going to talk a little bit about Crawford v. Washington and how it applies to these cases. Crawford is a Supreme Court case that dealt with what happens if a witness is unavailable for certain reasons, and when an out-of-court statement of an unavailable witness can be used. And Crawford really only applies to criminal cases, but it can be important to understand for civil litigation for a couple of reasons. Often we have companion criminal cases when working on civil elder abuse cases. And so, of course, it's helpful to understand potential issues that might come up related to your client's testimony in the criminal proceedings. But also something that we often see come up in civil litigation is that attorneys might use arguments that use the logic of criminal cases or criminal principles, even though they're not truly meant for civil cases. So civil attorneys can expect that some judges might be swayed by an opposing counsel's arguments that are like a Crawford argument. And so, being really aware of your state case law on evidence and on Crawford-like arguments, and I'll explain what I mean by that in just a second, can be really helpful to understand, when out-of-court statements can be used. So Crawford refers to a case that is about interpreting the Sixth Amendment of the Constitution that says that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. So a question that arises is if hearsay statements are put into evidence and the speaker isn't available for cross-examination, is that a violation of the Confrontation Clause? So in Crawford, the Supreme Court ruled that the prosecution can only admit prior testimonial statements of a person who's unavailable if the defendant had a prior opportunity to cross-examine them. But the Supreme Court did not define testimonial in that case. So generally, the results of what Crawford held was that the prosecution can introduce testimonial statements if the defendant did have an opportunity to cross-examine the speaker in the past, even if that speaker is not available to testify currently. And it does mean that anything that's a non-testimonial statement can be introduced regardless of cross-examination. So Davis v. Washington subsequently clarified that really what the meaning of testimonial is. So statements made in a 911 call asking for help were not testimonial in nature. So using the 911 statements, even if the caller was not available for cross-examination, does not violate the Confrontation Clause. So generally, statements are deemed testimonial when the circumstances surrounding the statements indicate that there's no ongoing emergency, and the statement is made to prove past events, or an interrogation is happening to prove past events, for the purpose of criminal prosecution or litigation, rather than for helping someone in an ongoing emergency. So some examples of testimonial statements are preliminary hearing testimony, grand jury testimony, prior trial testimony. So these are all testimonial, but that means that using them violates the Confrontation Clause. Therefore, it would not be allowed if there wasn't an opportunity to cross-examine. So with grand jury testimony and preliminary hearing testimony, often there is no cross-examination. So, but with prior trial testimony, often there will have been cross-examination. But, of course, the specifics depends on the state law and the circumstances. So additional examples of testimonial statements: victim and witness interviews by law enforcement, again, because those are done for the purpose of investigation and potential criminal prosecution rather than for helping someone in an emergency, is typically a testimonial statement. Certainly, there are some situations where the interrogation might be related to an ongoing emergency, and there might be a question of whether or not it's testimonial. But again, it's most likely when there are interviews from law enforcement, those are not going to be considered admissible because there is no opportunity for cross-examination. Affidavits and sworn statements and depositions are also all considered testimonial. None of them are made during ongoing emergencies and are usually about fact gathering related to past events and not, for providing aid during an emergency. So some examples of non-testimonial statements: 911 calls, transcripts, recordings when there is an ongoing emergency, or statements made to law enforcement when an emergency is ongoing. So law enforcement could provide, the specifics of statements that were made to them. Additional non-testimonial statements, casual or offhanded remarks to an acquaintance, statements to friends or neighbors, statements not offered to prove the truth of the matter asserted, and therefore they would not be hearsay. Really, anything that's not hearsay is really not Crawford and the related cases apply specifically to hearsay. So statements that are not offered for the truth of the matter asserted are not testimonial. I mentioned before that there's some question of whether or not interrogation by law enforcement is testimonial. So again, that just depends on the circumstances and the purpose of the interrogation. So a related exception to Crawford is that sometimes where there's forfeiture by wrongdoing, statements of a person who's unavailable can be introduced into a case, even when they're not available for cross-examination. So the Supreme Court case Giles v. California touched on this, and then there's also Federal Rule of Evidence 804b6. So if a defendant causes the victim to be, or the witness to be unavailable, and then all of the statements of the unavailable witness come in, and that's, very broad. It's not just the statements that would have been admissible if the witness was available, but actually all statements of the unavailable witness come in because the defendant's wrongdoing was for the purpose of preventing the witness's testimony. So of course, in abuse cases, this is often something that we see where a defendant might persuade or force a survivor to not show up to a court case, to not participate in an investigation or something else. And so that is considered forfeiture by wrongdoing. The way that this is proved varies from state to state. The majority view is that the proponent of the statements has to show by a preponderance of the evidence that the defendant caused the witness's unavailability. And a minority of states have clear, cogent, and convincing evidence, which is a higher standard, to show that the defendant caused the witness's unavailability. We have some examples of what forfeiture by wrongdoing can look like. Jail calls by the defendant asking the victim to drop the charges, tactics used by defendant to convince the victim not to report or cooperate in this or in prior incidents. If there are past incidents of the defendant threatening that if the survivor calls the police or they participate in prosecution, that they will be subject to harm, would be evidence and an example of forfeiture by wrongdoing. And generally with domestic violence dynamics and tactics, with the focus on coercive control and controlling the survivors' interactions with police and prosecution, can mean that the survivor generally is just not able to or willing to testify because of fear of harm. So that can also be an example of forfeiture by wrongdoing. So we're going to talk next about developing an abuse in later life case theory. Theory of the case can be really helpful when litigating a civil case. It allows you to present a consistent, concise, and persuasive case. The theory should be a story or theme that carries through the beginning of your case, your opening statement, through direct examination, cross-examination. The evidence you offer should support your case theory, and then through the end, your closing argument. Once you have a theory, you can think about what evidence and testimony can So there was a follow-up comment about the whether or not a law enforcement statement is testimonial. Yeah, so the Supreme Court uses I can give slightly more detail on this. The Supreme Court uses a test called the primary purpose test. So if the primary purpose of interrogation was to I'm trying to remember the language. So, but there's supposed to be an assessment of whether there is an ongoing emergency, what the statement is, and what the statement of the person, the speaker, or what the actions of the speaker and the interrogators were. So in general, a police interrogation, like in a police station, is going to be a testimonial statement, just to clarify. There are just some circumstances with ongoing emergencies where statements to law enforcement may be considered non-testimonial. Because they are related to ongoing emergencies. But yeah, as I said, the majority of statements or involved in interrogations to law enforcement are going to be testimonial. So back to theory of the case. The case theory can also be something that helps you figure out discovery that you need. If there are pretrial motions that you need to file, whether it's to understand or to gather certain evidence from the opposing party, like medical records, like we talked about before, or to help understand some arguments that the perpetrator may make in terms of what their defense might be. You can address that with your theory of the case and have it help you understand like the framing of your case that you're offering the court, so the court can have an understanding of what your client experienced and what their story is. So next. So your case theory should touch on subject matter jurisdiction, the elements of the case, and specifically the elements of what it is you're trying to prove. And it should be easy to follow and understand. And it should tell the court what the elements of the case are, what facts are important for those elements, and also address applicable statutes or case law that are crucial to finding in your favor. So developing your story is something that's really the basis of your case theory. So you want to describe what happened concisely and explain why that shows that your client needs the relief that you're seeking. So you want to figure out, how does what happened fit within the elements necessary to prove the case? What is going to be the other side's defense or response, and how am I addressing that? And what will resonate with the judge? And that can include understanding what is really important to your client. So what are the facts that they're stressing when you're talking to them, and what is important to them, both in terms of what happened to them and what they want from the court case. You need to make sure that your client is okay with your case theory and believes it's an accurate representation of their experience. You don't want the client to be hearing your case theory for the first time during litigation. It's really important to make sure that we're telling authentic client stories, and part of doing that means determining how we can tell a story on our client's behalf that is about the things that are specifically important to them. And then, build your case from there. So looking at what evidence fits into that, what will be the way to kind of get the judge to understand that experience, and also address any potential weak points or what the defense might be saying in their defense, and understanding the client's responses to the defense as well. So once you have your case theory, you should kind of figure out, how do I best present the evidence I do have, and what evidence goes with what element, who and what are the strongest parts of your case, what are the weakest parts, how can you best illustrate the evidence that you have, what is the best way to present it, in what order, through what witnesses, to actually tell that story told by the case theory. and make sure that you're, again, telling this really coherent, consistent narrative throughout your case. That is something that's easy for the judge to follow, and helps understand that helps the court understand the client's positions. You can use a theme to illustrate case theory. A theme is like a phrase or a sentence that will resonate with the judge and assist them in believing the story and remembering, what is important and how that relates to the elements. Strong themes are often used in opening and closings, and they can also be referred to during testimony. So for example, in a financial abuse case, a good theme is the bank records tell the story. So your theme would be grounded in your theory and the most important evidence. So saying the bank records tell the story and repeating that throughout the trial. So, in your opening statement, you're going to tell the court to pay attention to the bank records because the bank records tell the story. And then when you're, entering the bank records into evidence, you're using the phrase bank records again, so that the judge recalls that theme. And then in your closing arguments, you tell the judge, the court saw the bank records, then the bank records tell the story, and, go through the specifics that matter. And this will mean that, you've told the judge exactly what the story is going to be, then, pointed them to it as they go through the evidence, and then call back to it when you're doing your closing argument. Some more examples of themes. These are just a few different short, thematic statements that can help the listener hear about the evidence and categorize it and keep track of what's often, a lot of different facts or moving parts or pieces of evidence. And, it helps them understand things in a cohesive whole. So the abuser promised to take care of Ruby Price. Ruby's own words will tell us a different story. She will be the silent witness in this courtroom. It wasn't self-neglect. Ruby trusted him to care for her. The abuser had a duty of care. The judge should listen for her statements. So when you read that theme, in the first 3 sentences up there, it tells you what the important facts are about the case. So we're establishing that there was a duty of care that was not met, and the statements of the survivor are where the important evidence is.
Thanks, Ruth. In case you guys haven't noticed, in session 5, Ruth, the ABA folks really do the heavy lifting here. So I just want to say I appreciate you. I want you guys to be aware of some of the biases that not only juries and judges might bring to an elder abuse case, but anybody else, or even the older individual themselves, right? Because we know that that ageist bias is something that, like many other biases, we can internalize. But really focusing on the fact finders here, people may have the belief that somebody with dementia is not credible. Like if they have any kind of cognitive deficit, nothing they say can be taken seriously. Well, if you have been paying attention during the course of this training or a lot of the other trainings that we do, you know that somebody who has dementia can be very capable of accurately telling about what has happened to them. And there is research that has shown that even people with advanced dementia can actually recall accurately traumatic experiences that have happened to them. Traumatic experiences imprint on our brains a little bit differently. And even though they may get some of the details out of order, or they may remember different details at different times, it doesn't mean that they're not credible and that they're not accurately recounting their experiences. So it's important for all of us to keep that in mind. But as an attorney, if you're arguing something in front of the judge or in front of the jury, you may want to make sure that they understand that people with dementia is a spectrum, can range from not limiting someone at all to being very limiting, but we shouldn't make any assumptions about the quality of their testimony or their ability to recount their own experiences just because they may have some form of dementia. We also have to fight against the perception that neglect, which is not an overt action, right? It's a failure to act. there are some people that assume that because it's neglect, it's not actionable, that you can't be held responsible for something that you didn't do, which we know is false. If you have a contract or a duty, any kind of affirmative duty to care for somebody and you're not doing that, that can be actionable. Finally, there is a huge misapprehension that older abusers may be less dangerous, that because they're older, they can't really cause harm. Oh, how harmful can he be? He's so cute. That kind of stuff is also ageist, and we should not discount the danger that a perpetrator might play just because they are an older person. Let's advance. There we go. Oh, this stuff gets me worked up because it's so infuriating. Another bias that we often just see in elder abuse cases is that the belief that a crime against an older victim is less serious because they're old and they're going to die anyway. Even if somebody might not explicitly say it that bluntly, I think there can be layers to that in somebody's understanding of an elder abuse case. Like, I think as a society, people view it differently than, say, child abuse. So I think that we need to really check ourselves and then be very explicit with other people if we are arguing a case that, this victim is a human that has dignity, that has worth, that had a life that they were enjoying. And this victim, because of the crimes and the harm that was perpetrated on them, has had something taken away from them. And that is a fact, and that is something that should be concerning to everybody, regardless of the age of the victim. And I would ask, somebody who is saying that or who holds that belief, I would ask them if that is the way they would want to be treated if they were older and being harmed. Like, do you want someone to treat it less seriously because of your age? That's kind of the definition of ageism. And then there are folks that believe that people who have dementia don't suffer physical or emotional pain as deeply, or maybe if they do, they're going to quickly forget it. And I don't even know what else to say about that, except that it is untrue. People with dementia can experience physical and emotional pain, may in fact fixate on it. It can actually impact them more profoundly, more deeply. So that's a myth that we need to be able to identify and dispel. And then it's not uncommon for somebody to have sympathy or empathy for caregivers. Maybe you've got a jury comprised of people who have taken care of older adults, and they know that caregiving is hard. So I think that is something that can be present and that we need to learn how to address. And we're going to talk a little bit more about caregiver stress and its relationship to abuse in the next couple slides. So some of the common defenses that you're going to hear in these cases, I think number one that we train on all the time is consent. Either the victim intended to give the abuser his or her assets, or the victim, I wasn't neglecting the victim. They refused to get medical care. This is how they wanted to live. So they're making an argument that what was happening was self-neglect and not actual neglect. Or no, she wanted to engage in sexual activity with me. That was consensual. So consent is going to be your number one most common defense in these cases. You're also going to hear things like, oh, they were injured. It was just natural causes. They're older. Our bones do become more brittle as we age, and you may find somebody trying to exploit the natural progression of aging, and making that an excuse to cover up some abuse that has occurred. And then my personal favorite, caregiver stress. There is a lot of dialogue out there and a lot of belief that elder abuse comes from caregiver stress. I would love to know what you guys think about that before I go off on my rant. I'm gonna just take a look at the comments. Oh, Karen, I am here for you. Okay, so we're gonna talk about caregiver stress. Caregiver stress, first of all, I think one of the reasons that it became a myth, well, first let me talk about what it is. It's often an intent defense in cases of physical abuse or neglect. The prosecutor will be arguing that, you know, this person intended to harm them, and the caregiver is going to say, I never intended to harm them. I was stressed out as a caregiver. I may have been a little bit rough, but I'm not an abuser. I was just trying to do the best I could, and it got to be too much for me. It's more likely to be a tactic in a financial or a sexual assault case. But really what you want to be looking for is somebody who's just saying, I know what happened. Things got out of hand. I was in over my head. I should have asked for help. I couldn't. This person is creating a situation where they are making themselves the victim. So what we mean here by the difference between an intent defense and a tactic is, in many physical abuse or neglect crimes, the perpetrator's intent to cause harm is a critical element that you need to get a conviction, right? In contrast with sexual assault or financial abuse cases, the very fact that the conduct occurred may be enough to establish guilt. So you don't need to prove whether the offender intended to harm the victim when, for example, she looted her father's retirement account of all its funds. For those types of crimes, a defense tactic might be to argue that the perpetrator was acting under the influence of caregiver stress, with the implication that the perpetrator should not be held to the same level of accountability as a result. So it's a difference between arguing whether a crime occurred at all, or whether, yes, a crime occurred, but here's why the defendant did it. So, you know, please be understanding and go easy on him. All right. Some facts to consider when you are analyzing the claim of caregiver stress are the abuser's mental and physical capacity to provide care, the seriousness of the abuse, the caregiving and financial resources that were available to the abuser, whether the abuser took any steps to get help. Did they ask for help? Did they acknowledge that they were having a tough time? Did they try to get some respite care to come in? Is there a financial motivation for them to not seek assistance? All of these things and to get to that last point is really, really important in thinking about the co-occurrence of financial abuse and neglect. So look at the transactions for what is missing. Are they going wild on this person's bank account, but they are not paying for medical treatment? They're not paying for medications. They're not paying for home health aides or things that the person needs. Would the caregiver have benefited from that estate? Would it have been in their self-interest not obtain these resources for the older adults so that they can maximize the estate assets? Those are things to think about. But I want to get to Karen's comment about how can I respond to somebody who's always saying it's caregiver stress? First of all, I think that assumption is insulting to caregivers. There are lots of caregivers who provide care for people of all ages, all day, every day, and caregiving is stressful. Yes, they don't become abusers. The other thing I would say is if you've got somebody who has access to information and access to resources and is availing themselves of other resources in the community that can support them, but they're not getting help for the caregiving, it's really hard to buy that argument of caregiver stress. One thing I want to point out is that this whole idea of caregiver stress came out of a study that was done decades ago, where caregivers who were abusive were interviewed about their experience and why they abused. So if you are limiting your pool of folks that you're talking to caregivers, naturally, they want to present themselves in the best light, right? So when all these caregivers were interviewed in this survey, they said, yes, I was abusive, but I was a caregiver and it was super stressful and I didn't have help. So I'm not an abuser. I was just a stressed caregiver. So if the entire universe of people in your sample is caregivers who abused, that is likely you're going to get people who are looking to protect themselves and looking to explain away their actions, right? And maybe justify it to themselves. So the bottom line is there are resources that are available. If the person has the capacity to engage, and by this I'm talking about the person causing harm, if they have the capacity to conduct their daily lives and go spend money and purchase a car and do all kinds of things, but somehow they're not able to ask for help with the caregiving, but the caregiver stress is what caused them to become abusive, I am not buying it. in case you have not figured it out, I really get worked up about caregiver stress. I hope that that is helpful, Karen. It's just, I would go back to, I'm just going to flip back to these. Where did they go? Flip back to caregiver stress. Not this one, this one. So really kind of going through this as a checklist. You want to look at the abuser's mental and physical capacity to provide care. If they are engaging in the rest of their life without a problem and they're taking care of their own affairs and holding down a day job or doing things that taking care of business in every other area of their life except where they're providing care, then it really doesn't stand to reason that they would not be willing to bring in extra help or ask for help where they're needed. You can look at the seriousness of abuse. Certainly there are situations where somebody is providing care, but maybe they're not physically able to, they shouldn't be providing that care, and maybe somebody gets hurt and it is an accident. I mean, that certainly happens. But if you're looking at ongoing neglect or physical abuse or financial exploitation, that's going on for a long period of time and nobody is asking for help, that should be considered. So I hope that is helpful. It would be very frustrating to have a supervisor who is really focused on this issue. And I will say to the person who asked the question, if you want to talk about this more, I'd be happy to chat with you about this at some point if you want to email me. Just a couple other defense strategies that are pretty common in elder abuse cases is, and this goes hand in hand with caregiver stress, garnering sympathy for the abuser. Many times I already went off on caregiver stress. I'll be done with that now. But sometimes the abuser is dependent on the victim, and they're going to say, well, why would they harm them? They're relying on them for care. They love them. Or if the abuser is an older person, again, when I talked about bias, that's something that we need to overcome. Older people are very much capable of inflicting harm, just like younger people are. So those are some ways that the defense might try to garner some sympathy for the person who is causing harm. Another strategic defense that you guys all probably know way too well is delaying. That happens in all kinds of cases, but particularly with older victims, because I think sometimes the defense might be thinking, if we delay this, we kick this can down the road far enough, maybe that person won't be around. So be on the lookout for that. It is way too common. They may try to blame or undermine the victim and, say the abuse was a two-way street, or say things like, when the defendant was younger person, the victim abused them, things like that. Or plain intimidation and just, I don't know that I need to explain that, but that can be a common strategic defense. And maybe giving subtle messaging that, like, gosh, if you really want to go forward with this, like, it's not going to be great for you because this person was taking care of you and you don't want to end up in a nursing home, and it might be better not to bring this case at all. So those can be some of the defenses, either overt or subtle. Some of that messaging might be in play in some of these cases. I'll turn it back to Ruth. Thank you.
All right, so I'm just going to talk a little bit through direct examination and preparing your witness for direct examination. So the goal of testimony is to have your witness talk through undisputed facts and provide, supporting information about those facts. Attorneys should be asking open-ended, not leading questions, especially with older witnesses who can be, overwhelmed by the courtroom experience. It can be really helpful to kind of go in slow, step-by-step questions to ask about circumstances. Make sure you prepare with the witness to testify and practice. Make sure the witness is prepared for, what the court will look like. And what they can expect at court. In terms of, what you want to be asking about, you're always going to be drawing out questions, the who, what, when, where. You need to establish what happened on a specific date, what happened previously that's relevant, what context does the court need. who was present, are there witnesses? The judge or jury really needs to hear the story of what happened from your client and help them understand, what happened that caused the client to be seeking the relief that they're seeking. And it'll also help you lay any foundation for evidence that you're introducing. You want to lay the groundwork for the different relief that you're asking for, and lay foundation for evidence. During your direct examination, if relevant, you might be wanting to ask questions about times adult protective services were involved, questions to establish that the client is competent to testify, questions about relevant medical conditions and medical history, effects of medications, the role of caregivers, and normal or typical procedures at a nursing home. When preparing for direct, you always want to be prepared for potential objections, and the most common objection that people get is hearsay. So it's really important to be super familiar with the hearsay exceptions and exemptions in your jurisdiction. And so some common exceptions are spontaneous statements, excited utterances, present sense impression. A statement made for medical diagnosis might be important where there's statements in medical records. Contemporaneous statement, so statement made while the action was happening, explaining behavior of the speaker. Business records and other official records and dying declarations are also some examples. So just going to go through some strategies for cross-examination as well. Cross-examination should be really brief and to the point. You're not going to get a confession from an adverse witness, so you should be asking leading questions that are closed, elicit only a yes or no response, and focus on corroborating facts that are undisputed and minimize any damage that the witness's testimony, their direct examination did. Ask questions that corroborate your case theory and help figure out how you can use the adverse witness to corroborate elements of your case theory. You shouldn't approach chronologically or in the order that the witness testified, because you want to be controlling cross-examination rather than having the witness control it. And you should corroborate, small details and work back to big issues. Again, you're never going to have the adverse witness say exactly what you want them to say. It's important to remember when you can use information about prior bad acts. So you can use information about witnesses, bad acts to prove common scheme or design, lack of accident, or identity of the perpetrator. The rules on that are going to vary by your jurisdiction. Strategically, it can be helpful to draft cross-examination by starting with, using what we call the chapter method. And that means writing out a sentence, sentence by sentence, what it is you can prove with this witness, and then what questions you need to ask to prove that sentence. So, that with most crosses, it's going to be 3 or 4 basic points that are about what the witness can testify to that supports your theory of the case. So then you'll use the chapter method for each point and build questions, one on each other. And don't ask the final question where you put everything together. Instead, put all the answers together in your closing argument. So an example of the chapter method, the chapter that you're looking at, the statement is that the defendant had sufficient funds to obtain care for their mother. So the question is, your mother received a pension of $2,000 a month. She received Social Security of $1,500 a month. You and your mother shared a bank account. You were responsible for paying the bills. You had complete access to her funds. You owned your house free and clear. You owned your car free and clear. The only bills you had were for utilities and groceries. Utilities, you get a picture. So, asking these questions to build on each other and towards that point of about the financial status. You can use cross-examination to ask questions about the abuser's knowledge of the victim's dementia or any other vulnerabilities, times they had access or opportunity to commit harm, and, you know, their own ability or capacity, especially when they're an older abuser who older abusers are sometimes seen as not having the capacity to commit serious harm, like Anne talked about earlier. For neglect, oh, no, Anne, is that you?
That's me. So in neglect cases, you're going to want to explore the abuser's knowledge of the victim's condition, their dementia, or any other condition that might make them more vulnerable. Did they have knowledge of the victim's history of seeking or accepting medical care? Did they have knowledge of the victim's pain or discomfort as a result of the neglect? For example, in one of the cases that we use a lot in training, the perpetrator said he didn't know that his mother was crying out in pain, and he didn't know that she was suffering. And yet next to his chair in the living room where he would sit, he had earplugs, multiple pairs of earplugs that he used, that kind of stuff. The abuser's failure to use available resources. Did they have the financial ability to care for them and they just chose to allocate those resources elsewhere? And did they stand to gain financially as a result of the neglect? So was there money they should have been using to care for the individual that they just did not? And then in financial abuse cases, once again, did they know the person had some dementia and was not maybe aware of the state of their finances? What is the impact of the abusers taking on the victim's finances? Like, you know, how does it compare to what the person has left? Did the victim have a prior history of gifting and spending? And was that what the abuser was doing? Was it way out of line with their prior history? And then finally, how did they spend that money? You can use spreadsheets. You can use all kinds of cool infographics to show ATM withdrawals, online purchases, things that they purchased that clearly had nothing to do with caring for the victim, and only benefited the abuser. So I know we have only 3 minutes left. So I'm going to kind of fire through these last slides. However, we would be glad to take a look at or answer any questions that you guys might have. So I'm going to take a peek at the chat right now. Oh, we need to get you guys the slides. Okay. If that link, it should work for you guys. But I will email, when Christopher sends me the attendance report, I will email you guys a link to the slides for today, or just a PDF copy of them. And then also a link to the slides from somebody had asked about the slides from previous webinars, and we will get those to you. So keep popping your questions in the chat and I'll run through these last few slides. Just some key points for you guys to take away. Just remember the unique needs and challenges and experiences that older adults have when you are preparing them to testify in court. Using that thematic approach that Ruth explained so well is I think the best way to organize a case and to make it memorable and to make it clear and understandable for the finders of fact. And then finally, be familiar with the common defenses that are going to come up in elder abuse cases, because there's definitely some greatest hits there. And you are going to hear the same things over and over. Understand the weaknesses in those defenses and be prepared to explain to the judge or to the jury how those defenses can be overcome by the facts of your case. We really appreciate you guys being here with us today, and being here for the whole series. I want to let you know that we have a bunch of resources on the NCALL website. I know Ruth talked in the beginning about some of the things you can find on the ABA's website, which is terrific. We also have a video library with a ton of clips that you can use in your own trainings or just for your own education. Similarly, our YouTube channel has about 150 streaming videos on different training topics, some victim stories, forms of abuse, lots and lots of stuff. We have Awareness Month and outreach materials available for your use on our website. Everything we do is free. So please, you can sign up for our newsletter. You can follow us on the socials, although I think we're getting off Twitter and we're going to be on Blue Sky and Threads. So look for a change there. But I just want to, Ruth dropped the link to their website in the chat. I don't see any other questions. I really appreciate you guys being here. I love that there's always good interest in this series. We welcome your feedback. We're going to be sending out an evaluation in the mail in the next few days in the email. So we would appreciate your feedback. We like to tweak this to make sure that it's relevant and interesting and useful for you guys. So please let us know what you thought. And thank you. Thank you, Ruth, and everybody at the ABA. It's always great working with you guys. And thank you to Christopher and the team at NCJFCJ. We definitely wouldn't be able to do it without you guys. So thank you.